Hi, I'm Anna Denton-Jones and I wanted to use a recent case to illustrate two issues that could emerge when there's a redundancy scenario. In this particular case, it happened to be a law firm and an individual who had a disability. He had sleep apnea and type 2 diabetes, was managed out of the business using redundancy as the reason for dismissal. In evidence, it was clear that there'd been some concerns about this person's performance for quite a long time, but clearly not been managed. There are obviously also issues around that person's attendance, and perhaps that wasn't being managed either. So it's quite common in these sorts of scenarios for an employer to leap on redundancy as the opportune moment, if you like, to tackle something that perhaps they haven't been managing properly before. And in this particular case, there was some correspondence that the individual came to see that reflected, if you like, that perhaps management were seeing the opportunity to exit him alongside others when there was a genuine redundancy exercise going on. But the court felt that correspondence that showed that management were viewing this as the opportune moment was evidence that the actual application of the redundancy situation to him was a sham, and that really what was going on was that there were other reasons for his dismissal. The second problem that emerged in the case is that the solicitor was actually in the pub and overheard colleagues talking about him, and that the redundancy exercise was this opportunity to manage him out. And he was able to put forward that evidence as well. So it just shows how careful anybody who is involved in a redundancy exercise needs to be, and they need to remember not to be talking about it in the canteen, not to be talking about it in the coffee shop, not to be talking about it with colleagues in the pub, because you just never know who is listening and who may pick up on these things. The same is true with email, and it's very easy for people to treat email quite informally and in a quite a chatty way, to be messaging each other about something internally in work, where if you applied the would you want the employee themselves to see this, think twice about what they were committing to writing. So it is worth drawing to people's attention that, of course, under the GDPR, the individual can have access to that email correspondence by making a subject access request. But I've even known colleagues to take photographs of managers' screens or screenshot and send to colleagues, for example, emails that they think their colleagues might want to see. So you do have to be very, very careful. If you do have any questions about redundancy, please do email me, adenton@refreshinglawltd.co.uk. Thank you very much.